Hi, my name is Mike Matray, and I'm your host of Healthcare Matters, where the medical and legal community comes together to discuss healthcare matters. Today, my guest is Craig Brodsky. Mr. Brodsky is a partner with the firm GOODELL, DEVRIES. Welcome to Healthcare Matters, Craig.
Good morning.
Right now, the most discussed topic in healthcare is the Affordable Care Act. Do you see any areas where the Affordable Care Act affects medical liability litigation, and if so, what is that?
Sure. Well, the interesting thing that's sort of been an outgrowth of the Affordable Care Act is this mandate, the individual mandate to buy insurance policies. And when we deal with high dollar or catastrophic injuries in malpractice cases, we're seeing the Affordable Care Act impacting how damage claims may be put together. This is a very emerging area of the law, and it's really not clear how the various jurisdictions are going to address it. But the individual mandate might have a very significant impact on catastrophic injury claims, and specifically how and what plaintiffs might recover for future damages. Oftentimes in catastrophic injury cases, the future medical bill claims can be exorbitant. We're talking sometimes in excess of $2, $3, $5, $10 million for people who have severe brain injuries. The Affordable Care Act, though, has eliminated certain problems, though. For example, there's no pre-existing injury claims, and everybody has to have insurance. So in theory, a person could go out and buy a health insurance policy that will cover all their care for the rest of their lives. That's a lot cheaper than paying for the actual care. The question is whether the states will allow the type of a damage, purchasing health insurance for a claimant and covering out-of-pocket expenses as opposed to the actual dollar amounts. This goes against what litigators know as the collateral source rule, which means that money that comes from another source does not reduce the damages owed. It's an old policy back from English common law. So what we're going to litigate in the near future is whether buying an insurance policy and paying the out-of-pocket costs for somebody can substitute for the high dollar costs of care. And that's going to be an interesting issue that's going to play out throughout all of the states.
Excellent. Well, thank you, Craig, for spending your afternoon with us here on Healthcare Matters. And good luck to you, and I hope to speak with you in the future.
Thanks very much for having me.
How has it affected best practices for entering data into a patient's chart? And what guidance would you give to physicians so that they're using best practices when entering data into their electronic medical record?